You ever have one of those awkward moments where you realize you just wasted time, energy? I had one of those today. This is a Carolina in Fort Worth video, Parker County First Amendment audit. I'm not really concerned. Like, she walks around videotaping in the parking lot and stuff like that, and it's just your general level of auditor douchebaggery. And that's not really the reason why I'm bringing it up, because we've seen countless thousands of videos where auditors stumble around through police parking lots until they get trespassed, and then they all shake their fists that they're being trespassed. Well, they can't really shake their fists because they're in handcuffs, but you know, they get handcuffed, they go to jail, they bond out, they plea bargain, and it's done. And most of the time, you never hear from them again. A few times where they've built their channel and their reputation on it, they continue to do it. Um, I don't know how many times somebody has to get arrested in a police parking lot for trespass or other things before people get it through their heads that the First Amendment, state law may, but the First Amendment does not protect you in uh, on police parking lots, police stations, things like that. Just because it's open to the public doesn't mean the First Amendment protects your activities there. But that's not why we're dealing with this one. We're dealing with this one because she goes in here and she attempts to make a public records request. Texas does have a public records request law. It's not 5206 like she says it is. It is in the government code. Normally, you start off with what code it's in. In this particular one, it's in the government code. Government code 552 et sequitur. If you think it's 552.06, no, it's not. You can look it up yourself. I'm not wasting my time on it. It's just really not. So I did a lot of research on this. 552.021 means that the government body has to have they have to make the information available during their normal business hours. 552.029 is the inmate information they're required to make available publicly. 552.134 essentially limits the public information on inmates to what is listed in 552.029. 552.221 does say that you have to give your application for the public records request to a public information officer. Not just some random dude, but to a public information officer. They have to respond in a prompt manner. And by respond, I mean they have to either tell you, either they have to give you the information you were requesting, or they have to tell you how long it's going to take to get it, or they have to tell you it's denied, something along those lines. They can't just leave you hanging. They can, however, point you to a website, and luckily enough, Parker County does have a website where you can look up all that juicy information on inmates. 552.228 says that they have a reasonable time to provide you with a copy, and reasonable does take into account all the circumstances that it requires. They don't. It's not what you think is reasonable. It's what the government agency is reasonably capable of doing. 552.230 allows that particular government body to make procedures, to put procedures in place on how the request is made. Maybe they require you to access an online request form. Maybe they require you to fill out a specific kind of form, et cetera, et cetera. And then 552.231 says that they can charge you for not only for whatever medium they're giving it to you on, like if they have to put it on a disc, you have to pay for the disc. If they mail it to you, you have to pay for the postage, but they can also charge you for like any time it takes to compile the data. If it's going to take them, an hour to compile the data, maybe they charge you $40 or something. I don't know. But yeah, it's not always going to be free. And I did all this research because I'm stupid. I didn't notice until after I had already done the research that this guy's shirt doesn't say Parker County. It says LaSalle Corrections. And imagine my shock. Imagine my shock when I realize that the Parker County Jail at 612 Jameson Street in Weatherford, Texas, is in fact operated by LaSalle Corrections. Which leads me back to 552.003. I do not believe that they fit the definition of a governmental body. You can make an argument that they do. I'm not saying that you can't. I would fathom that they're not. They are a private corporation. Yes, they are contracted with the government, but they're a private corporation, and I don't know for sure that they would have to give you those public records. At least I don't believe that they are bound by the government code. The government code isn't really designed to deal with them. So I think that was wasted time on my part, and I know it was wasted time on Caroline and Fort Worth's part, but she's getting attention and that makes her happy. This is Happy Freeman. We're on a completely different topic. This is Happy Freeman. He streamed this on the 13th, June 13th. He is discussing events that happened on June 12th. On June 12th, he went to the Pima County Sheriff's. They presumably acted like fools. I can't be certain that they acted like fools because the video isn't available because James Freeman hasn't had a chance to edit it for content yet. Excuse me, edit it for time, because of course he would never edit it for content. They were asked to leave. That is the definition of being trespassed. Being asked to leave, you're trespassed. You're no longer welcome on the property. You need to leave. You're being trespassed. James Freeman doesn't understand that, so he says they were asked to leave, and then they were threatened with being trespassed if they didn't leave. Actually, they were being trespassed, and they were told that if they didn't leave the property, then they would be arrested for criminal trespass. Catilla asked, and James thought it was relevant somehow, whether or not they'd committed a crime. That is an old auditing myth that you can't be trespassed from public property unless you've committed a crime. Here's a fun fact. If you're asked to leave public property, provided the trespass statute is worded appropriately, this doesn't work necessarily like this in California, but if you're asked to leave public property and you refuse to leave, you are now guilty of a crime, the crime of criminal trespass. So check your state laws. So James Freeman suddenly wants to place his criminal case above his activism, even though he chided his previous attorney for wanting to do the same thing. And James Freeman beat feet to the traditional public forum of the sidewalk. Now, he's very happy in this particular stream because the Three Stooges he was with the previous day had decided to go back. They went back to the Pima County Sheriff's Department and the jail, and they were going to be auditing that jail because, gosh golly, it's unsettled law as to whether or not you can engage in First Amendment activities or whether the First Amendment protects you from arrest on jail property. This is a sad James Freeman. This is a very sad James Freeman. This James Freeman is very sad because the Three Stooges are being arrested when he's making this. He says they're being detained. Well, they're being arrested. Why are they being arrested, you ask? Well, let's let James Freeman explain his frustration to you.
I mean, how much longer is this going to go on? How much longer, the precedent has been set again and again and again in multiple different, in the Supreme Court as well as multiple different appeals courts.
At this point, you expect me to challenge Mr. Freeman's assertion that it's already been determined in the Supreme Court and multiple circuit courts, but it in fact has. It is very settled law. So I am 100% in agreement with Mr. Freeman on this point.
I mean, at this point, I'd have to say that it's completely intentional, willful, and malicious.
And I agree with him on that point too. At this point, it is completely intentional, willful, and malicious. And stupid. I would add stupid. This has been decided since 1966. Adderley v. Florida. Students were protesting around a jail. They were told to leave. They didn't leave. They were arrested for trespass in Florida. Nothing in the Constitution of the United States prevents Florida from even-handed enforcement of its general trespass statute against those refusing to obey the sheriff's order to remove themselves from what amounted to the curtilage of the jailhouse. Curtilage is the property surrounding your house, so they're making an analogy. Essentially, your curtilage is your driveway, your front lawn, your side yards, your backyard. If you imagine that your house was a jail, the curtilage would be all the property surrounding it, immediately surrounding it. That's where these people were, and nothing in the Constitution prevents Florida from trespassing them. The same would apply to Arizona. The state, no less than a private owner of property, has power to preserve the property under its control for the use to which it is lawfully dedicated. The state can keep that jail as a jail. It doesn't have to turn it in to a First Amendment protest zone. For this reason, there is no merit to petitioners' argument that they had a constitutional right to stay on the property over the jail custodian's objections, because this area chosen for the peaceful civil rights demonstration was not only reasonable but also particularly appropriate. That's essentially the argument that these auditors keep making over and over again. They have a right to be there because they're trying to film X, Y, or Z. They're trying to do a public records request. They're trying to do this or trying to do that. That is exactly the argument that these auditors keep making. And here, the court goes on to say, such an argument has as its major unarticulated premise the assumption that the people who want to propagandize protests or views have a constitutional right to do so whenever and however and wherever they please. That concept of constitutional law was vigorously and forthrightly rejected in two of the cases petitioners rely on. We reject it again. The United States Constitution does not forbid a state to control the use of its own property for its own lawful, non-discriminatory purpose. As long as that jail was, or those sheriffs were enforcing policies that were, or rules or statutes that were viewpoint neutral and reasonable, they had every right to, under the First Amendment, I'm not talking about state law, but under the First Amendment, there's nothing in the First Amendment that would preclude them from enforcing that and from kicking you off of that property or trespassing you or criminally trespassing you for failing to comply with those regulations. Thank you for watching. Have a great day.